Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Zulkifli bin Badur. I'm from DEN 2 and my matrix number is 30 DEN 19F 1028. Today I'm going to talk about business law, and there are four topics that I will tell you guys, and it's actually five, but I will talk only four. Okay, for the first topic is law of contract. Second is legal aspects of business entities. And the third one is law of agency, and the fifth one is sales of goods. So the first topic is law of contract. First thing that I will tell you guys is the definition. An agreement between two or more persons that is legally binding between them. All contract is an agreement, that is to say, all contract must be built upon an agreement, although not all agreements are automatically contract. Second thing is basic of contract. It's like promise. There are two, which is mere promise, that is generally not enforceable. Second, binding promise, enforceable by law. Next is types of contract. There are three types of contracts, which is valid, void, or voidable. The first one is valid. A contract will be valid if all the 9 elements of a valid contract is fulfilled. I will tell you guys the 9 elements after this. Okay. Effects: if a breach of contract happens, the parties affected may end their contracts and enforce their case to the court and claim remedies. Okay. Effects of refusals of party to perform promise wholly. Okay. They use one section, which is section 40. When a party to a contract has refused to perform himself from performing his promise and its entities, their promise may put an end to the contract unless he has signified by words or conduct his acquiescence is its continuance. The second one is void. When a contract is void, it is not valid. It can never be enforced under state or federal law. Void contract is valid from the moment it was created and neither party is bound by terms. And the last one is voidable. A contract will be voidable if it made without the free consent of the parties. Effect, the effect. If the parties affected does not allow consent, the contract will be void. Okay, I'm going to tell you the basic element of a valid contract. Like I've told you before, there are nine. Okay. The first one is proposal or offer. Second one, acceptance. The third is consideration. The fourth is subject matter. The fifth is intention to create legal relations. The sixth is certainty. The seventh is legal capacity. The eighth is free consent. And the last one is legally of the object. If we can make a contract, we also can discharge a contract. There are one, two, three, and four types of discharge of contract. The first one is discharge by performance. The performance must be precise and exact, fulfilling completely the contractual undertaking. There are two sections, which is section 38 column 1 bracket 1, and second one is section 38 bracket 2. Okay. The second one is discharge by agreement. Can be discharged if the party to the contract agrees or consent that the contract will be discharged. Also two sections. which is 63 and 64. Next is discharge by impossibility of performance. Terminated if the things that the parties agreed to do are impossible to perform. Also two sections, which is section 57 bracket 1, section 57 bracket 2. And the last one is discharge by breach. The contract can be put to an end if the party to the contract did not do what they have promised to do in the contract, which is the contract will be cancelled. If you promise something, then when you don't do what you promise, the contract will be cancelled or discharged by breach. Alright, the second topic is legal aspect of business entities. As usual, if you have a business, you can register your business at SSM. SSM stands for Suruhanjaya Syarikat Malaysia. Okay. There are three types of business entities in Malaysia. I'm not sure if in the world, but in Malaysia, yeah, there are three types of business entities. The first one is sole proprietorship, where one person is invented in running a business for himself, just himself. The owner is just himself. That's all. And the second one is partnership. A partnership is the relationship that subsists between two or more persons carrying on a business in common with a view of profit. The business is not incorporated. You also can register the partnership at SSM. Just two person or more doing same thing, such as selling burger. In the same time, they look up for a profit, the same profit, like they look for a profit. Okay. And the last one is company. The third and dominant form of business organization is the incorporated company. In Malaysia, company means a company formed in with the Companies Act 1965. You also can register the company at SSM. And the special things about company is the liability. There are two things, which is unlimited liability and can sue or be sued in his name. For example, you can buy a building using your company's name. So when you don't pay it or you do anything about the company wrongly, the building, the government can sue your company, not your name. Something kind of like that. Okay. Next is types of company. Like I said before, okay, I never said before. Okay, there are six actually, which is the first one is enterprise, second is limited liability partnership, third is private limited company, fourth is public limited company, fifth is companies limited by guarantees, and the last one is foreign companies. Okay, for the enterprise, can be sole proprietorship or by partnership. Next one is limited liability partnership. Is a mix of private limited company and a partnership company. And the third one is private limited company. Most common types of business entities in Malaysia because it has a separate legal identity. For example, when you buy, like I said before about the car, the building. Okay, you can separate the identity. And the fourth one, next one is public limited company, able to offer its shares to public. Um, Preferred business model for large business. For this example, I will use Apple. When the CEO died, the company is not died. You just change the CEO. It's either the children, anyone, I don't know, but the company is not die, just like the owner. Okay, because it shares the shares to the public. Okay, you can buy the shares, um, which means if you own a bigger share, you're the owner. You're the biggest owner. But there are a lot of owner, not just one, because it's not limited. Okay, and the fifth one is companies limited by guarantees. Involves the liabilities of the moments being limited. Company used by not-profit organizations such as foundations and charitable. And the last one is foreign companies, equivalent to a foreign branch in Malaysia. You guys know, right? The um, outside brand like Apple, like Nike, some kind of that. The third topic is law of agency. Okay, the first one is definitions. Agency is a relationship which subsists between the principal and the agent who has been authorized to act for him or to represent him in dealing with others. For example, the boss and the worker. Principle. Section 135 Contract Act 1950. The person for whom such act is done or who is so represented is called the principal, the boss. Section 136. Any person who is of the age of majority according to the law of which he is subject and who is sound mind may employ an agent. So when you be a boss, you have to be sound mind, which is you have to be normal. So you can employ an agent and a worker. For the agent, section 135. An agent is person employed to do any act for another or to represent another in dealing with third person, which is the third person is the customer. So the next one is section 137. Any person may become an agent, but no person who is not of the age of majority and of sound mind can become an agent so as to be responsible, which means if you are not sound mind, I mean if your age is not past the 18, you cannot be an agent because of the law. Next is types of agency. There are 6. And the first one is agency by express appointment. The principal appoints the agent expressly, either orally or in writing. Section 40. An authority is said to be expressed when it is given by words spoken or written. This is the easiest way to be an agent, which is you go to the interview, some kind of that. You send a proposal or something, okay? The next one is agency by implied employment. Section 40. An authority is said to be implied when it is to be inferred from the circumstance of the case and things spoken or written. The ordinary course of dealing may be accounted circumstances of the case, implied from the relationship of husband and wife. Wife is an implied agent to husband. The third one is agency by ratification. Ratification, acceptance, may happen on two situations. When an agent who has no authority has acted as if he has the authority to act on behalf of the principal. B. Second one is when an agent has exceeded his given authority. Next one is agency by necessity. Person who has no authority may become an agent due to this necessity or emergency circumstances in order to protect the principal from any loss. Real and emergency. The agent was entrusted with the principal. Impossible for the agent to get the principal's instruction. And the three one is the condition the condition to be the agent by necessity. The fifth one is agent by estoppel. May happen when the principal himself induces the third parties to believe that a person, not an agent, was authority to act for him, as if that person is his agent. The last one is agency by function. A. Broker, an agent who does not have possession of the goods. B. Faster, an agent is that the agent has possession of the goods before case. Last one is auctioneer, an agent appointed to sell goods by accepting bids. The last topic is sales of goods. Definition of goods. Goods includes every kind of movable property other than actionable claims, and money includes there are two, which is stocks and shares and growing crops. There are one section which is section 2 Act 1957. Next is contract of sales. Definition section 4 bracket 1 of SOGA. A contract of sales of goods is contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. Sale, section 4, bracket 1, SOGA. A contract under which the property title in the goods is transferred from the seller to the buyer. Implied condition in SOGA. Next one is implied condition in SOGA. Implied condition as the title section 14. Section 14 A. Section 14. Okay. Next is agreement to sell. Section 4 bracket 3 of SOGA. A contract under which the transfer of the property in the goods is take place at future time or subject to some condition thereafter to be fulfilled. If the seller breaches the agreement, the seller may be sued for damages. If the buyer breaches the agreement, the buyer has only personal remedy for the damages against the seller. Next is implied condition in SOGA. Implied condition as to title section 14 bracket A. First one is title is also known as ownership. B. Second one is In a contract of sale, there is an implied condition on the part of the seller that in case of a sale, he has a right to sell the goods. Last one is, in an agreement to sell, he will have a right to sell the goods at the time when the property is to pass. Next is agreement to sell, section 4(3) of SOGA. A contract under which the transfer of the property in the goods is take place at future time or subject to some condition thereafter to be fulfilled. If the seller breaches the agreement, the seller may sue or damages. If the buyer breaches the agreement, the buyer has only personal remedy for the damages against the seller. Next is nemo dat quod non habet. It means no one can give a better title than himself possesses. In other words, the seller cannot sell the goods that he does not own. This is because he has no title to the goods. The seller can sue for breaches of Seller can be sued for breach of implied condition as to title under section 4(a) of SOGA 1957. We're using section 27(1). There are a few exceptions of nemo dat quod non habet. First is estoppel. Second is sales of mercantile agent. Next is sales by joint owners. Next is sales under a voidable contract, and the last one is sales by a seller in possessions. Last but not least, implied warranty. Quiet possession of the goods, section 14(b). In a contract of sales, unless the circumstances of the contracts are such as to show different intention, there is an implied warranty that the buyer shall have and enjoy quiet possessions of the goods. Example, if Anggun bought from Bubut a stolen smartphone owned by Fatiha, now the smartphone is claimed by Fatiha. Anggun can claim a breach of quiet possession of the phone from Bubut. The smartphone. Next is section 14(c). An implied warranty that the goods shall be free from any charge of encumbrance in favor of any third party not declared or known to the buyer before or at the time when the contract is made. Example, laundry service which have to be paid before the goods can be collected. If not, you cannot collect your laundry. Right. That's all from me for business law. I hope anyone who watched this video can learn something new for the law. And for me, I think law is very powerful because you can rule a country if the law is yours. That's all for me. Thank you.